Ready? Start. In the present case, since the only averments which are mentioned in the plaint are with respect to inheritance of the properties by the defendant, that is, the father of the plaintiff from the grandfather of the plaintiff are ancestral properties, it cannot be said that the plaintiff can have any rights to the properties inherited by the defendant from his own father, in as much as inheritance of properties by the defendant from his ancestors will only make the properties in the hands of the defendant as self-acquired properties and not HUF properties in view of the ratio of the judgments of the Supreme Court in the cases of Commissioner of Wealth Tax, etc., supra and Yudhishthir supra. The sole ground on which the aforesaid findings have been assailed is that the appellant plaintiff in paragraphs 11 and 12 of the plaint has described the properties as co-parcenary, that the grandfather of the unfortunately died on 14/11/1999, and thus the above said properties specifically detailed in the Annexure A annexed with the plaint devolves upon the defendant and the plaintiff equally in the ratio of 50-50, being co-parcenary properties in the hands of late Sri Joginder Singh, grandfather of the plaintiff. Thus, as per the ratio of the aforesaid decisions rendered by the Supreme Court, the properties inherited by the grandfather of the appellant plaintiff on the demise of his own father were held by him as his personal properties, and in which his son, that is the father of the appellant plaintiff, did not acquire any share. The question of the appellant or plaintiff inheriting any share from his grandfather therefore does not arise. The claim of the appellant of the properties being ancestral properties in the hands of his grandfather is based only on the fact of the same being ancestral properties in the hands of his great grandfather, and it is in this context that the appellant has claimed them to be co-parcenary properties, though no foundation whatsoever has been laid in the plaint of any HUF being in existence at any point of time. This court has, in a number of decisions relying upon the judgments of the Supreme Court supra, has elaborated on this aspect of the matter and held that the plaintiff, in order to make out a case for a share in the property otherwise than under the Hindu Succession Act, must plead that there existed a HUF since prior to the coming into force of the Succession Act, and such HUF continues to exist. The appellant plaintiff in the instant case has failed to make out any such case. The Hindu joint family is purely a creature of law and cannot be created by act of parties save insofar that by adoption or marriage a stranger may be affiliated as a member thereof. An undivided family, which is the normal condition of Hindu society, is ordinarily joined not only in estate but in food and worship. Therefore, not only the concerns of the joint family but whatever relates to their commonality and their religious duties and observance are regulated by the members or by the manager to whom they have expressly or by implication delegated the task of regulation. The joint family status being the result of birth, possession of joint properties is only an adjunct of the joint family and is not necessary for its constitution. Nor is it necessary that all the members possess rights or status, even though the property of the family is called joint family property. The first respondent was a minister and subsequently chief minister of Haryana state. Later, he became union minister. On 12/11/1987, a complaint was presented before the Haryana chief minister wherein serious allegations were levelled against the first respondent. The main allegation were that he accumulated huge properties worth crores of rupees in the names of his family members, relations, and persons close to him by misusing his power and position and by undervaluing the market price, and all those transactions were benign in character. According to the complainant, since the accumulation of the properties by the first respondent in the shape of buildings, land, shares, ornaments, etc., was far beyond his legal means, an investigation should be directed against him. The Chief Minister's Secretariat marked the complaint to the Director General of Police, who in turn endorsed the same to the Superintendent of Police concerned. On the direction from the Superintendent of Police, the SHO registered a case under sections 161 and 165 of Indian Penal Code 1860 and under section 52 of the Prevention of Corruption Act 1947 and took up the investigation. Source is 3P Legal RHC. Exercise number is 51. Words are 762 and speed is 100.